So very, very good afternoon, friends. So warm welcome on behalf of Doctors Risk Medico Legal Services, an organization which is working for doctors from last 16 years. I was also a doctor, but for the cause of a doctor, I surrendered my medical degree in 2012 and opted for Bar Council registration. And today I'm practicing lawyer in High Court and Supreme Court, and handled almost 16,000 issues, which has helped me in learning a lot of things. Because I strongly believe the best way of learning is teaching and executing whatever knowledge you have got. So today I'm here with all practical knowledge, which I gathered in the last 16 years rather. And the most important, the practical knowledge I gained during the court proceedings, which I have started aggressively attending post 2012. I enjoyed this profession much, no question. I enjoyed my doctor profession also, great pay. But I feel well satisfied because I could able to give a justice to many of my colleagues and doctors who are in trouble due to antisocial activists or extortionists during the practices. With that in mind, I thought what could be the best if I want to reach across the country to protect my doctor. I found that knowledge is one thing, even if you're not there, and my colleagues had got a knowledge of the law, they can by themselves protect them in any of issues and situation. With that in mind, I started a knowledge sharing sessions. And in knowledge sharing session, I see to it that I part all my experience to my people with only interest that if at all they have got this knowledge, so they can protect themselves from the extortionists, they can protect themselves with antisocial activists, they can protect themselves by their knowledge itself. In matter of member of a doctor's risk, medical legal services or not, the organization which protects the doctor, having a professional indemnity policy with the doctor's risk, I see to that all my colleagues should get benefited with my presence and my knowledge. And I am really in a peace and feel fulfilled when I share my knowledge on different topics. As demanded by many of my colleagues who have attended the past sessions, today I thought of enlightening you on various landmark judgment of this country when it comes to medical law. Why judgment? Because the judgment is as good as the law in this country in absence of medical law specifically designed or defined for the same. There is the only way of a parliament who makes the law when it is a central act, or assembly who makes the law when it is a state act, or naturally local bodies. In absence of all, many of the time, such a scenario situation comes in front of a court that they need to fill the vacuum. And then the Honorable Supreme Court, Honorable High Courts, National Commission, define and decide the matter. And unless it is overruled, it becomes the law of the land. So friends, these judgments act as good as a law in this country and governed by various laws. So friend, let's understand, but before I proceed for that, I can see that Dr. Ashok is asking a much questions related to CPA Act 2019 and its impact on health services. Let me clear that so that he can listen to this session with a clear mind once query gets solved. To all my colleagues here and friends, please don't get impact or influenced by the social media or viral media posts without any authentication. In recent past, I've seen lots of posters floating on WhatsApp media saying that health sector has been dropped from Consumer Protection Act, and then Rajya Sabha has passed. My friend, at least be vigilant to see the publication of that particular post. You will utter shock that this publication was done in 2020. But today in 21, we are floating the same. Feeling very happy that health sector is dropped. Answer to this is absolute no. Health sector word is dropped from the definition of the act because of agitation done by the people. But the definition structure is not at all changed. The definition structure of 1986, where again the health sector word was not there, got interpreted by Supreme Court, and then medical services were brought under CP Act, is the same which is in 2021. Again, the health sector word is not there. But the word which is already there was, and today also, is that including but not limited to. This is the law word which always get interpreted. So including but not limited to insurance services, builder services, etc. Here the health services was already put, which was dropped. But by dropping this, the main meaning of definition is not changed. So including but not limited to includes health sector. So the viral message of dropping of health sector, which you may be reading today, is of 2020 June. Now we are in 21. I spoken on this topic for hundreds of times with all evidences why medical negligence has been brought under CPA Act, including the definition, including the notification, including the rules of mediation. Section 4 very clearly mentioned that the cases of a medical negligence except the grievous injury and death can be taken for mediation. And what else needed? In 2020 July, when this act got executed in this country, today, if you ask me, hundreds of cases already got filed under new act for medical negligence. So now there should not be any doubt under the mind of a doctor that we are not under the CPA, because court has already admitted hundreds of the medical negligence cases today under the CPA 19.